This is an unequivocal, clear holding that a president will be immune from prosecution for violating not only the Constitution, but any criminal statute.
This is Brad Rourke with the Charles F. Kettering Foundation. We're a nonprofit, nonpartisan operating foundation that focuses on advancing and defending inclusive democracy. Today, I'm talking to Kettering Senior Fellows Neal Katyal and Judge J. Michael Luttig about the recent Supreme Court decision in the presidential immunity case, Trump v. United States. Neal Katyal, I'll start with you. What is this decision saying?
Well, I think it's a big win for Donald Trump. The decision itself really is a change in our constitutional structure, a very deep one. The traditional rule that I've taught constitutional law 20 times, traditional rule has always been no person is above the law. That is not quite true anymore. The court has basically carved out an area which they call official acts, as to which the president or former president now has immunity. Bottom line is massive change to our constitutional structure and in the direction of a monarch.
And Judge Luttig, you said this a similar thing. You said on Twitter or X, this decision means we can no longer say that no man is above the law. Could you elaborate on that a little bit?
The decision earlier this week was a constitutional abomination. It was unsupported by the Constitution itself, by a single precedent of the Supreme Court of the United States in the 250 years since the founding of our nation. No one thought before Monday that the President of the United States of America would be immune from prosecution for grave crimes, or any crimes for that matter, that he committed against the United States while in office. This decision, though in an entirely different context, Brad, will be, in my view, the Dred Scott decision for the Roberts Court. The American democracy and the rule of law, I have said, are the heart and soul of America. We fought a revolution in America against Great Britain and the King so that our President of the United States would not be above the law. And as of Monday, there is no question whatsoever but that the President of the United States, and in particular the former President of the United States, is above the law in America. What the court has wrought can never be undone until or unless the next Supreme Court that's willing overturns this egregious decision in the name of America, the Constitution, and the rule of law.
Neal, let me go to you real quick. You were former acting Solicitor General of the United States. You've argued over 50 cases before the Supreme Court. So I want to maybe be unfair to you and ask you, judges said this decision means no longer is no one above the law, but Justice Roberts would say that's overblown. What's his argument? What's he saying?
Yeah, so the Chief Justice, for whom I have a great deal of respect, says that it doesn't mean nobody is above the law because there'll be case-by-case adjudication as to whether something is an official act or not. And that's true insofar as it goes, and it certainly means that some things a president won't be above the law for. For example, I think pressuring state legislatures to have a fake slate of electors. But that's just a narrow set of the allegations against Donald Trump and a narrow set of allegations that would come against any future president. Take, for example, what Justice Sotomayor says in her dissent. And this is coming straight from Trump's argument. I mean, Justice Sotomayor at the oral argument asked Trump's lawyer, wait, you said to the Court of Appeals that if the president sends out Navy SEAL Team 6 to assassinate his political rival, you'd say that's an official act entitled to immunity. And the answer from the Trump lawyer in the Supreme Court was basically yes. I want to talk about Justice Jackson. And here I mean not Justice Ketanji Jackson, but Justice Robert Jackson, because what Justice Jackson understood after serving as Attorney General and a high-ranking executive branch employee is the pressure on a president to push the envelope and have his advisors say, you can do this, you can do that. And what Justice Jackson said in the Korematsu opinion, which dealt with the Japanese American internment, what he said in dissent was that idea, that power is going to lie around like a loaded weapon for some future president to pick up. And the same thing is true here. I don't doubt that the Chief Justice means what he says, but what he said was that, for example, pressuring the Justice Department to throw out the integrity, to impugn the integrity of the 2020 election, that was an official act. As against that, assassinating a political rival certainly would be just as much. It's an exercise of the president's commander-in-chief power. And to have that principle lying around like a loaded weapon, not just for the next president, but for future presidents, is atrocious. And so I absolutely agree with Judge Luttig. This is one of the darkest days for the Supreme Court. I do not think this decision will stand the test of time. It will be ridiculed and ultimately overruled.
Neal, you mentioned Korematsu, an infamous decision. Judge, you're one of the most important legal scholars today and a renowned conservative jurist. You mentioned this as being the Dred Scott decision. How poorly is this reasoned, and how infamous will it be seen by history?
Well, Brad, we know how this opinion came to be. The public needs to understand that the Supreme Court has rarely addressed presidential powers. And every time it has written the narrowest opinion possible. And that's for all good reason. Here's how this opinion came to be, and I am as certain of this as I am of anything in this world. The majority of the Supreme Court decided that Donald Trump would be deemed immune from prosecution on the charges that had been brought against him by the United States by Jack Smith.
Yesterday, Kettering President Sharon Davies wrote a piece that pointed out this Roberts Court has a history of opinions that demolish long-standing settled opinions. Citizens United, Shelby County, Dobbs. How activist is this court? Neal.
Well, I do think this court is increasingly out of step with the mainstream of American society. And, 2 years ago, it was Dobbs overturning Roe versus Wade. Last year, they overturned the Bakke decision on which university admissions had been based since 1978. So this is a court that some have called the YOLO Court, the You Only Live Once Court. They are deciding so much and so fast. And, legitimacy is best preserved by going slow, by issuing narrow opinions, akin to what Judge Luttig was just talking about, and by being cautious and respecting the precedent and wisdom of justices who've gone before you.
Justice Barrett wrote a separate opinion. Where does she differ from the Roberts majority opinion, and is it important? Neal.
Yeah, I do think it's important. One of the things she says is that the evidence of official acts could be introduced in a way that the majority said you couldn't. And this is playing out in real time right now with the New York hush money prosecution and an allegation by Trump that verdict has to be thrown out because the jury was presented with a couple official acts of Donald Trump, even though all of the allegations in the case are before Donald Trump became president. Indeed, the whole point of the criminal indictment is to say in October of 2016, Trump was hiding campaign contributions in order to make him the president. So this is all about pre-presidential conduct, but unfortunately, the way the Supreme Court wrote the majority opinion, there's some suggestion that maybe this evidence will be barred, and Justice Barrett is taking issue with that. I think the other really significant thing about Justice Barrett's opinion is she just comes out and says, look, there is no argument whatsoever that when Donald Trump pressured the state legislators about the fake electors and all of that, that is somehow an official act of the President of the United States. If I'm Jack Smith, I am right now trying to pare down my allegations in the indictment, bring those forward, because the American people deserve at least a trial on that. Before the entire thing might be shut down by Donald Trump.
I was talking to someone yesterday, and they pointed out that what this decision essentially does is it gives a blueprint to any future president to engage in completely despotic behavior, just so long as they keep their conversations to their core power agencies. So Justice Department, military. Is it that bad?
Yeah, it is that bad. And all the president has to do is slap on the label, this is an official act.
Brad, I wouldn't quibble with your characterization of it as a blueprint, but I would say this. It's far more than a blueprint. This is an unequivocal, clear holding by the Supreme Court of the United States of America that a president will be immune from prosecution for violating not only the Constitution, but any criminal statute. As a practical matter, virtually every single thing the President of the United States does is and will now forever be an official act for which he will be immune from prosecution.
This seems a mind-boggling ceding of power by one of the three co-equal branches of government to create such power in one of the other branches. Do I have that wrong?
I think you do have it wrong in one sense, because it is the court taking the power for itself and basically saying, look, we're not going to tell you everything that's an official act or an unofficial act. The court's kind of it depends answer is a way for it to have more power in this area. And the loser is, of course, the Congress, because Congress has passed all sorts of statutes that forbid criminal behavior. And now all of them have a little asterisk. Again, it's very hard to understand this to be at all consistent with the rule of law as we've understood it for over 200 years.
Just imagine if the Supreme Court had done the only thing that it's supposed to do under the Constitution of the United States and decide the question before it. We would have had a holding today on whether or not the former president could be prosecuted for his criminal offenses in and around January 6th. What do we have instead? The Supreme Court has roiled the nation. It brought to mind a statement made by a justice who I will not name. That justice said, "We are writing for the ages." That's the last thing that a Supreme Court justice should ever say, let alone think.
Neal Katyal, what are you looking at? What are you watching?
I'm waiting for Jack Smith to try and ask the Supreme Court to issue the mandate immediately and to send the case back to Judge Chutkan. Judge Chutkan would then have the opportunity to have an evidentiary hearing as to whether these things we've been talking about are official acts, like pressuring Vice President Pence, like pressuring state legislators, and all of that. And in the course of that evidentiary hearing, the American public could get to see some of the evidence that so far has been hidden from them. Yes, we've had a January 6th committee, but as Liz Cheney, who helped run that committee, told the New York Times, they didn't actually have access to a lot of the evidence that Jack Smith has had because they didn't have the full subpoena power and other things. So the American people, I think, really deserve to see that evidence before the November election. I'd like to see those proceedings begin quickly. We've waited now almost 4 years since the January 6th attacks, and still the case hasn't been made to the people. The evidence has not been presented to the people, and that is tremendously, tremendously unfortunate. So that's what I'm looking for right now.
Kettering Senior Fellow Neal Katyal and Senior Fellow Judge J. Michael Luttig, thank you both for your time and energy and your service to America.
Thank you.